Okay, it's 1:02, so I shall make a start. Good afternoon, everybody, and welcome to this cost update on behalf of Bristol Law Society. For anyone that I haven't met before, my name is Nicholas Lee, and I am a cost lawyer at Paragon Costs Solutions. I hope you can all hear and see me fine. As I've said, if you can't, then please do pop your problem into the question and answer box, and somebody will be able to respond to you. So this is a 2020 update, if you like, on some of the recent developments in the cost world. And despite COVID, there continues to be a pouring of case law coming from the courts. And just wanted to give you an update as to those that I think are most interesting and most relevant to you. I'm going to start with solicitor and client disputes. And I'm very sorry to start on a low, but I can assure you it only gets better from here. There's been a number of cases really which I think are important for you all to be aware of, and you'll see at the end of this I advise you all to have a close look at your CFAs and retainers to make sure that you don't fall foul of any of these recent cases. So the first one I want to talk about is the case on your screen, which is Toms versus Brannan. This was a case where the claimant law firm terminated the CFA after limitation had expired and in the absence of instructions to issue proceedings. So naturally, there was no way the claim was going to be able to succeed and proceed, so they terminated the CFA. The claimant alleged that the defendant, so the claimant is obviously the law firm, the defendant was there instructing the client. The claimant alleged that the defendant had failed to keep to his responsibilities, and therefore this triggered a liability under the CFA for the client to have to pay the basic charges and disbursements. And those of you that are familiar with CFAs will know that there's a number of standard clauses. So for example, if a client terminates the CFA before you achieve a win or a lose, then the solicitor has a right to charge their basic fees and disbursements. If the solicitor terminates the CFA because the client hasn't kept their responsibilities, again, that can trigger a liability for basic charges and disbursements. But if the solicitor terminates because there are no longer sufficient prospects of success, then ordinarily they're only liable to charge the client for their disbursements. So in this case, they said that the client hadn't kept their responsibilities by giving proper instructions to issue proceedings before the limitation period expired. However, the court found that in fact, the claimant, the law firm, was responsible for not acting in the defendant's best interest and failing to advise properly and promptly. So I think in this case, they'd received instructions in 2015, but it wasn't until 2017, shortly before the limitation period expired, that they gave the client a full advice on the merits of the claim and the steps to take. And in fact, the client didn't have very long to make a decision as to whether to issue proceedings. So the court said that the solicitor, the law firm, could have done better. And in fact, the defendant, the client, was not in breach of the CFA. And therefore, in effect, the claimant had, or the solicitor had terminated the CFA because there was no longer prospects of success because of limitation. And therefore, because they terminated the CFA, all they were entitled to charge would have been their disbursements. So the claimant's claim for professional charges under the CFA was dismissed. So the lesson we learned from this case is to have regard to who is terminating the CFA, why it's being terminated, and what are the consequences, and particularly to pay close attention to this when drafting the CFAs. And if you're thinking of terminating, you want to be sure that you're terminating on the appropriate grounds. Continuing the solicitor and client theme, this was a PI case where £385.50 was deducted from damages. And the reason I specifically give you that figure is because at the end of this, I'll tell you how much the parties spent in this dispute. Just a reminder of the law in relation to charging your clients. Section 74(3) of the Solicitors Act 1974 says that the amount on a solicitor and client assessment cannot exceed that which the court would have allowed as between party and party. But many of you will have terms in your retainers which contra this, and this is permitted pursuant to CPR 46.92 that says that this can be overridden by written agreement. But the question in this particular case was whether informed consent was required. And what had happened is what I would call the typical case, which is the client care letter says, you will be liable for our costs. We may get a contribution from the other side, but come what may, you will be liable for our fees, and whatever is recovered is a contribution. So at first instance, District Judge Bellamy held that the client care letter contained sufficient information and the deduction was permitted. However, Mr. Justice Lavender disagreed. And what he said is that an explanation should have been provided as to the amount of the likely unrecoverable costs. And that would have enabled the client to have asked for some kind of cap or to make an informed decision as to whether they want to proceed. So a client effectively has to give informed consent to deduct unrecovered costs on damages. So as I say, in this case, an example would have been along the lines of, our fees may be £2,000. We expect we may be able to recover £1,500, and therefore £500 may be payable from your damages. So that's the level of detail that Mr. Justice Lavender effectively says is required, and I have to say it's not the level of detail that I commonly see. So again, I should imagine that will have many people reverting to their client care letters to perhaps give a little bit more information as and when required. The final of my depressing solicitor and client cases is a case which I hope I pronounced right, Iwanyawa versus Ratcliffe solicitors, and these are all cases from this year. As I've said, this was before Master Gordon Saker, who's the senior cost judge in the SCCO. And what the solicitor had done in this case, which is what many law firms do, is they had sent invoices on a monthly basis, and their client care letter said, we will invoice you on a monthly basis. You're liable to pay these invoices, and you can seek an assessment if you wish. But what Master Gordon Saker said, which is in my view a development, and again, many client care letters I see would fall foul of this, is said that the retainer must state if invoices are intended to be final statute invoices. And if they didn't expressly say that they would be final bills for the period, and what that meant, then in effect, they wouldn't be treated as final statute invoices. Between solicitor and client, what that means is that at the end of the case, the client can have all of the solicitor's costs assessed, because on a solicitor and client basis, there are limits. If you render a final statute invoice, you have an automatic entitlement within a month. But if more than 12 months has passed since the invoice is paid, then the court has no jurisdiction to order an assessment of those costs. But of course, if your invoice is not a final statute invoice, then those timeframes don't apply. So all 14 bills in this case were capable of assessment, because the client care letter didn't go far enough to say this is a final statute invoice, you have a month to have this assessed, and thereafter you may not have the same rights, and spell it out in such clear terms. And what this means in practical terms is you could have cases that have been going on for 3 or 4 years. The client has been happily paying throughout, they're perhaps unhappy with the outcome at the end, and unless your retainer expressly states that the invoices would be final bills for the period they cover, the client may well be able to go back for many years and have those bills assessed. So slightly worrying developments, and they all seem to be favouring the clients at the moment. So I suppose it begs the question of why the rise, and I think that the days of you'll pay nothing, no win, no fee, if you like, and no deductions will be taken from your damages, those have gone. And certainly in lots of commercial cases, those days never existed, and the clients always knew they'd be liable for costs. But I think that cost recoveries are getting tougher because of proportionality and cost management, and clients inevitably are paying more if it's meaning that the other side are having to pay less. I think clients are also becoming more aware of their ability to challenge your fees. It's a sort of consumer-led market, if you like, and there are firms such as Check My Legal Fees that will be encouraging clients to go and have a word with them to see whether there's any ability to challenge your legal fees, even if in principle the client was very happy with the service. And it seems that the courts are saying that clients aren't expected to interpret the wording or understand cost law or understand the law behind your retainers. It's your duty to carefully explain everything. So that means carefully explaining their liability for costs, carefully explaining what may be recoverable, and carefully explaining invoices. A client may not know the difference between an on-account invoice or a final interim invoice, for example. And in fact, many lawyers I know probably wouldn't be able to explain the difference either. So it is your duty to carefully explain that to the client. So my advice in summarising this particular section is it's probably time for a bit of a health check. If I were you, I would take a look at your client care letters, have a look at your terms of business, and also look at the wording that's on your invoices, just to ensure that it is going to be compliant with these recent decisions. Moving on to Precedent T, and with my Bristolian accent, it often comes across as President T, and no, we're not talking about the American election. This is the new precedent for cost management cases where you need to revise your cost budget. There was a lot of excitement around this from the 1st of October, and lots of mail shots, I'm sure, in your inboxes. So I thought it might just be helpful to give you a summary. Not much has changed, in all honesty. There is effectively a new form, but there has been some subtle changes. So you would have seen, if anyone's looked at the rules, that some of the previous practice direction from practice direction 3 has now been moved into the actual rule itself. The main significant changes relate to, as I say, the Precedent T, which is the form to amend your budget, and I'm going to take you through that in a moment. The form requires that particulars of the additional cost must be confined to the significant development, and I think that's quite helpful, because of course you're entitled to revise your budget if there's been a significant development, and you're required to say this has been the development and these are my additional costs. So it's not significant just to say, well, the budget that I'd set previously was insufficient or I wasn't allowed enough. There has to be a development in the litigation, and you have to identify what costs are as a result of that development. As has always been the case, it must be done promptly, and you should also seek to agree it with the other side before applying to the court, so no major changes there. I just wanted to highlight the section about oppressive behaviour before I show you the form, because it says in the rules that any party may apply to the court if it considers that another party is behaving oppressively in seeking to cause the applicant to spend money disproportionately on costs, and the court will grant such relief as may be appropriate. And of course, that relief is likely to come in the form of either an increased budget or some kind of cost sanction, or maybe having the budget not apply at all. But the reason I wanted to highlight this particular section is because I don't think it will be sufficient at the end to rely on a party's conduct as a good reason to depart from the budget. Because this is written within the rules that if a party is misbehaving, then you can apply to the court. I think the court will say, well, why didn't you apply at the time? It's not, the whole point of cost management is to give transparency to all parties and to enable the court to manage the costs and manage the case. So just a word of warning that if a party is misbehaving, I would raise it at the time and raise it with the court if necessary, if it's causing increased costs, rather than saving that until the end. So as promised, I will take you through the Precedent T. You'll see that the layout is similar to the existing cost management precedents, the Precedent H and the Precedent T. I'm hoping you'll be able to see my cursor, because I'm just going to draw your attention to certain sections. You'll see the headings are broadly the same. In this grey section here, the applicant, the party applying to revise their budget, has to set out what costs have already been incurred as at the date that the budget was prepared, and what costs were approved or agreed, again, as at the date of the cost management order or as agreed between the parties. So in effect, that resembles what has already been agreed between the parties or approved by the court. You then have to set out, as you'll see in yellow, the variation. And the variation has a plus or a minus sign. I find that rather amusing because cost management has been around now for 7 years or so, and I'm still to see a single party apply to vary their budget downwards. You're supposed to, if there's a significant development that means that your budget or your cost will be less, then you're supposed to apply. I've not seen a party do that. I'm not sure what the consequence is of failing to do so, but I suspect we're most likely to see variations wanting to increase budgets. So within the yellow box, you have to set out what the proposed variation upwards is, and then in the final yellow box, you'll see there's a total estimated cost after the variation, and there's also a section for the court to complete the amount that they're allowing. And this is the detail that sits behind it. You'll see again in yellow, you have to set out the time and the disbursements in relation to this variation. This part does frustrate me slightly, because I think it encourages debates between the parties as to how much time is being spent, the hourly rates, the amount of council's fees and disbursements, etc. And we've been told time and time again that cost management is broad brush, it's not a detailed assessment. The court should simply allow what is a reasonable and proportionate figure. So it seems to me that having to break it down in this way perhaps just encourages more disputes, but there we go, that's the process. You'll see that it'll give you a total figure, but more importantly, you have to set out in this column what is the significant development which gives rise to these additional costs. The imposing party, much like they would in a Precedent R, has an ability then to make an offer and to make any comments, and those comments may well be, this is not a significant development, or it may well be, these costs are excessive and a lesser sum should be allowed. So we will see how this evolves over time. As I say, this has been introduced since the 1st of October. I haven't yet had to complete one of these myself, and I have to say that variations to budgets are perhaps worryingly low. I think they should be far more frequent. It's often the case that I pick up cases at the end and I see that there was very good reason for perhaps applying to revise the budget at the time, but it wasn't done. And the real danger is that if it's not done at the time, the court, when dealing with the cost assessment way, may well say, well, you should have applied at the time, there was a significant development, and having failed to do so, I'm not going to say that there's good reasons to depart from your budget. So that is the Precedent T, as I say, not incredibly exciting, but hopefully just talking you through that document will help you if you need to complete that. What else has been happening in the cost world? Well, there was an interesting case which I will come on to for Master Gordon Saker, dealing with what is recoverable between the parties. But I thought I would just start with a bit of an introduction, because the rules themselves don't set out much as to what is recoverable between the parties. It's CPR 44.3, it simply says costs must be reasonably incurred and reasonable in amount. The only other guidance really is Practice Direction 47, which effectively says you can't have routine letters in because the 6 minutes allowed for the routine letter out includes considering the letter in, and you won't generally be allowed local travel expenses, postage, courier fees and copying. So that's all really the rules say. Everything else, I think, is a matter of the cost lawyer's experience or the discretion of the judge. But I think what was an interesting development was a case of fusion earlier this year. It was a decision of Master Gordon Saker, and he said this. He said, reasonable time spent in inter-fee discussions is properly allowable. It is difficult to delegate tasks to junior fee earners without instructing them what to do, and the reasonable time of the delegator and the delegate is usually now considered to be recoverable. Now, this surprised me because I'm pretty certain in probably very similar words I put this argument before Master Gordon Saker, and he said that inter-fee discussions were not recoverable. So I'm not quite sure when the tide changed, but I'm pleased that it has, because as he said, it is entirely logical that if you need to delegate tasks to somebody, then you should be allowed the time spent for doing so. So I think this is a very helpful decision. It's a High Court decision, so not necessarily binding on every court, but the fact that it's Master Gordon Saker and he's the senior cost judge, I think it's likely to carry some weight. And also gave some more guidance on things that are perhaps common knowledge and what is probably the usual approach. More than one fee earner attending trial with counsel won't generally be reasonable. Multiple fee earners attending the client or witness, again, won't generally be reasonable unless there are some exceptional circumstances. And of course, the time spent copying trial bundles is not recoverable. Now, he did distinguish between the time that's spent thinking about the trial bundle index and perhaps putting together the master copy, if you like, but somebody physically standing at the photocopier and copying the bundles, their time for doing so is not recoverable. But as I say, the takeaway from this, and moving on to my better news, is that hopefully inter-fee earner discussions, providing delegation is necessary and reasonable and saves costs, should be allowed in principle. Also, hot off the press from September was a case of PLK. Now, I should say this was a Master Wayland decision, and he was dealing with guideline hourly rates in the context of quarter protection cases. And for anyone that doesn't deal with quarter protection cases, their bills are always, this is where there's a patient and an appointed deputy, and the deputy's costs are always assessed by the SCCO, and almost in every case, the guideline hourly rates are applied. So there was, in effect, a test case before Master Wayland to consider whether those guideline hourly rates were still fit for purpose. Lots of evidence to suggest that the hourly rate should be increased. Master Wayland quite rightly said guideline hourly rates have not been revised since 2010, and many detailed assessments are rendered effectively useless. And it's worth also just pointing out that the rates are under review again. The last time they were reviewed, there was no change. And I know there's been a call for further information, so whether they will change or not, who knows. I think it's time for a change personally, because the guideline hourly rates are so out of date that they are effectively useless, whereas if they were brought up to date, then they may be more helpful. But in any event, back to the PLK case, what Master Wayland said is that rates of approximately 120% of guideline hourly rates should be regarded as reasonable in quarter protection assessment. So that's a 20% enhancement on the guideline hourly rates. And I suppose my question is, could this be the starting point for fast track cases? Because Those guideline hourly rates were designed for fast track cases and for summary assessments at the end of fast track trials and interlocutory applications, etc. And if those are the same rates that were applied in the Court of Protection, then why should it not work both ways, in that if effectively the guideline hourly rates are so out of date that a 20% enhancement is appropriate, then why shouldn't that be the case for fast track cases? Just to give you a bit of an illustration as to what that means in monetary terms, you'll see the guideline hourly rates in a band 1 area such as Bristol for a grade A fee earner 217, for a B 192, for a C 161, and for a D 118. Now with Master Wayland's 20% enhancement, what I'll call the PLK rates, that means that the grade A is now 260, the B is 230, the C is 193, and the D is 142. So I would say that that's a glimmer of hope that that should be the starting point for fast track and low value multi-track claims, in my view. And it also begs the question of whether that gives a bit of a springboard for the starting point for multi-track rates. Now, of course, there aren't any guideline hourly rates for multi-track cases, and I've plucked some figures out of the air, which, in my view, given this analysis I've given, ought to really be the lowest sort of rate that the courts will be allowing for multi-track cases. There will always be exceptions, and I'll give you some examples of my recent experiences. But in my view, this ought to be the lowest, and that would be sort of 280 for a grade A, 250 for a grade B, 210 for a grade C, and 150 for a grade D. So important to note that if the guideline hourly rates are changed, then it's likely the Court of Protection practitioners will be bound by the new guideline hourly rates. But for now, they have a 20% increase, and hopefully this will give those reviewing the hourly rates a bit of a steer as to what should be appropriate. I thought I'd just give you a bit of an insight as to some recent assessments we've had in Bristol and the hourly rates that were allowed. Of course, hourly rates are always at the discretion of the court, and this isn't by any means a benchmark, but hopefully it's interesting. I'll start at the right-hand side because that's the lowest value case, and you'll see it's settled pre-issue, and that's the claim settled pre-issue. The claim value was 13,500, so it wasn't a high-value claim. But notwithstanding that, the court still allowed up to £300 an hour for the grade A fee earner, and then applied guideline hourly rates for the other fee earner. So even with a claim of that value, the court's allowing £300. So it does lend some weight to the rates I suggest on the previous slide. Moving on to the other cases, you'll see both settled pre-issue. One valued at 95,000 or settled for 95,000, the other settled for 180,000. So a little bit higher in terms of the value of the claim. But you'll see there the top rates, 310 and 320 pounds an hour. And you'll see that for these higher value claims, the court has been far more willing to deviate from the guideline hourly rate. So this is a bit of an example of what the courts may allow. I wouldn't place too much reliance upon it, but it demonstrates that there is a significant movement away from the guideline hourly rates, which, as I say, I think is a good thing. I want to deal with this case of Bandal versus the commissioners for HMRC. It was an SCCO decision from June this year. The claimant agreed, and it's important I should stress that the claimant agreed to the terms of this particular order. It wasn't imposed. But the claimant agreed that unless he made a payment on account of costs by the 6th of February that year, he would be debarred from taking any further steps or actions in the detailed assessment proceedings. And that is the type of unless order that a party could seek in the absence of a payment not being made. As is perhaps obvious, he failed to make that payment, and therefore he applied for an extension and for relief of sanctions. And what the court said was that this was a serious and significant breach. The defendant, in this case the HMRC, had been deprived of their money since 2014 and 2015. Therefore, relief was refused and the extension was also refused. So what it meant in practical terms was that the claimant was debarred from taking any further steps in the detailed assessment proceedings. Now, they had already filed points of dispute, so the court said, well, we will still conduct the detailed assessment based on these points of dispute, but as would normally be the case, the parties can make all submissions, the claimant will be debarred from doing so. So I suppose the summary here is that the benefits of applying for an interim payment are twofold. Firstly, we're all told cash is king. So of course, if you can get an interim payment, then great. And the rules have changed in recent times to say that the court will order a party to make a payment on account of cost unless there's good reason not to do so, and the courts will typically make that order. But an inability to pay shouldn't necessarily deter you, because as the court said in Bandau, there could be a sanction that if a party doesn't pay, they'd be deprived of taking part in the detailed assessment. So it may give you a slight upper hand. And I say may because I have a practical example of this, not where a party was debarred necessarily, but the paying party in a recent detailed assessment simply didn't turn up. They had points of dispute being prepared by a cost lawyer. They disinstructed that cost lawyer before the detailed assessment, and they had no representative. And it sounds great, but what it meant is for 2 days, I had to make the paying party submission as per their points of dispute. I had to make our reply, and then I had to be interrogated by the judge. So in other words, the judge stepped into the shoes of the paying party and probably done a better job than the paying party would have done themselves. So it was a tough 2 days. So I do question whether there is a significant advantage to effectively the judge stepping in place of the paying party, because there is, of course, the duty on the court to ensure the costs are reasonably incurred and reasonable in amount. And I can assure you that the judges are much better advocates than some of the opponents I've been up against. So I'm not sure it's always an advantage, but one to bear in mind and one to think about, particularly if you can get a party debarred before they file points of dispute, because you may well then be able to get a default cost certificate. I want to just draw a distinction between some of the recent cases on interest, and in particular pre-judgment interest, and the difference between the decisions that have been being made in PI cases and in commercial cases. It always surprises me when people are surprised to learn that their clients may be entitled to judgment pre-interest, pre-judgment. Of course, many of you are aware that from the date of judgment, you're entitled to 8% interest. But it's been the case for some years now, the court has discretion to award interest pre the final order, if you like. And I've taken you on a quick history tour. I'm not going to go into the detail of the first few cases, but just to highlight what the Court of Appeal has said. So in Powell 2002, the Court of Appeal said that pre-judgment interest can be awarded, and of course that's now within the CPR itself. In Bim Kemi, the Court of Appeal said that 1% above base rate for pre-judgment interest was appropriate, and that would be payable from the date of the invoice was paid or the costs were paid up until the date where, if you like, the default judgment rate would apply of 8%. And more recently in 2013, there was the Jones case where the claimant solicitors within their CFA inserted a charge for 4% above base rate for the cost of funding disbursements. And the High Court in that case said that that rate of interest of 4% above base rate pre-judgment was recoverable. But then we move on to some cases from earlier this year, and the first bullet point, the fourth bullet point, the Marlborough case and Nosworthy are PI cases. And what the High Court said in both cases was that interest incurred under a disbursement funding loan cannot be recoverable as costs, and they relied on a decision known as Hunt v Douglas, and that was applied, as I say, in both Marlborough and Nosworthy. So if you take out a disbursement funding loan, you cannot recover interest, the interest on that loan pre-judgment. But compare that with Sharp, and Sharp was a decision 4 days after Marlborough, again in the High Court. And what the court said is the court may order interest on costs from a date before judgment. That's well known. It's common ground that this will generally be exercised where a party has had to put up money to pay its solicitors and has thereby either lost the beneficial use of that money or has had to borrow it. So in a commercial case, if you had to borrow money, you're entitled to pre-judgment interest. But in a PI case, if you've had to borrow money by way of the disbursement loan, you're not entitled to that interest. So there seems to be some conflict here between PI and commercial cases. And I wonder if part of this stems from the fact that historically, perhaps PI cases have been funded by the lawyers, and maybe the courts see this as the lawyers just trying to get some benefit from the sort of the entitlement to pre-judgment, as opposed to a client having to physically go and get their own loan. But in my view, I think that's short-sighted. I think that if there is a disbursement funding loan and where a client is being required to pay disbursements as they go on in their cases, as many are now required to do. Why shouldn't that interest be recoverable as prejudgment interest? It's a fundamental principles in our civil cases that a party should be put in the position that they would have been in but for the tort, and therefore if they've had to take out a loan to fund their litigation, why shouldn't they be entitled to the rate of interest they've had to pay, providing that was reasonable? So watch this space. I think this is going to be a development. My own view is that Shark is probably the correct way forward, but we will see. Moving on to ADR, my new favourite subject. I'm sure you've all heard many decisions where the courts have imposed sanctions, but there have been 3 recent decisions which I will take you very briefly through just to highlight that the court is taking this very seriously. There is the DSM versus Blackpool Football Club case from March of this year. The claimant had beaten their own Part 36 offer, and I flagged that point because it would be very easy for either the claimant to say, well, I'm already going to get some costs on the indemnity basis, there isn't any point in seeking any more, but in this case that they had a go. And there could be some attraction to a judge saying, well, you've already done all right out of this case, so any further entitlement to indemnity costs would be unfair. But the courts aren't doing that. As I say, claimant beat his own Part 36 offer that was made 2nd of December 2019, but they sought indemnity costs for a broader period on the basis that the defendant refused to engage in ADR. Now, what the defendant said at the time and at the conclusion was that it had reasonably refused mediation on the basis that it considered it had a strong defence. But the court said no. No defence, however strong, by itself justifies a failure to engage in any kind of ADR. Even if you think you're certain to win, then come to ADR and present your case. Let's have a conversation about it. Simply refusing ADR is not good enough. So in this case, the claimant got an additional year's worth of costs on the indemnity basis from the 1st of December 2018 for the defendant's failure to engage in ADR. Similarly, in BXB, claimant again beat their own Part 36 offer, so they had an entitlement to indemnity costs from 30th of July 2019, but they sought indemnity costs prior to that date, again due to the defendant's refusal to engage in ADR. And I think what's perhaps notable in this case was that Deputy Master Brown had made what I would call the usual order at a CMC, that the parties should consider ADR, and that any party not wanting or not willing to engage in ADR should provide a witness statement within 21 days of the proposal and that refusal. In this case, the defendant failed to do that. They failed to give any reasons why they're refusing to engage in ADR. So again, claimants got part indemnity costs from an earlier date, being 25th of February 2019. I suppose it's important just to flag that indemnity costs do remain attractive. Of course, there is the shift in the court's approach to an assessment in that on the standard basis, doubt is resolved in favour of the paying party, but on the indemnity basis, doubt is resolved in favour of the receiving party. So generally speaking, it means that you recover a little bit more. Also, on the indemnity basis, proportionality doesn't apply, and as there's been cost management, then you only have to show good reason to depart on the standard basis. So it's on the indemnity basis, in effect, the cost management order won't apply to those particular costs. So there are 3 very good reasons why cost and indemnity basis are attractive. And I should say it works both ways. As you'll see from this case, it applies to winning defendants also. In this case, the claimant sent 2 letters of claim, both offering ADR. CBRE initially said that ADR would be premature. The claimant continued to recommend ADR, suggest ADR throughout the proceedings, but CBR never engaged in that process. They eventually won, so they probably thought, well, we knew we were going to win, so ADR would have been pointless. But they were deprived of part of their costs for their failure, and they were deprived of up to 50% of their costs for refusing to engage in ADR. There was a bit of a sliding scale depending on certain dates, and one of the other defendants was also deprived of some of their costs for different reasons. It just goes to show that the courts are taking this very seriously, and as I say in the lesson here, win or lose, you're likely to face sanctions if you unreasonably refuse to engage in ADR. So I think you have to be very brave to say no thank you to any ADR. And of course, I don't think it will be beneficial to say yes for the sake of saying yes and then turn up and not engage in the process. That's not what is intended. The intention is that you turn up in an ADR and you do engage in the process. So what about ADR in the form of costs, and can it work, will it work, and when should it apply? I think ADR is very powerful for dealing with preliminary points, and the examples I've given here, things like what is the appropriate hourly rate, whether the costs are disproportionate, whether there's good reasons to depart from a budget, whether there's any challenge to the retainer, or whether the CFA is enforceable, any issues about late acceptance of a Part 36 offer. Obviously that can, if the parties can't agree, sometimes you have to go back to the court for determination if there's late acceptance of a Part 36 offer, but again, that's something that could be resolved through ADR. Any issues about conduct or the application of qualified one-way cost shifting. In effect, it's those big points that prevent cases from settling. I think that without these points, many cases can settle, because there is, of course, the old age-old rule of thumb that a party can expect maybe 60 to 80% of their costs on a standard basis, and maybe 80 to 95% of their costs on an indemnity basis. Don't quote me on that, that's just the general rule of thumb. And most parties understand that, but where I think they fall out and where they can't approach that sort of exercise in that same way is where they have these big ticket items that could mean that the cost should be 40 or 50%. So I think that having somebody independent either provide an evaluation or a binding determination of those issues should lead to the ability of the parties to then go on and settle these types of claims. Of course, if you need any more incentive, look at the delays in dealing with detailed assessments. I recently managed to get a lengthy hearing in a court next year, but I was told by the judge in that particular case that if we were in the SCCO wanting 6 days, as it was, we would be waiting until early 2022. So there's definitely an attraction for all parties wanting to resolve things quicker to consider ADR. Then, of course, there's the cost of the detailed assessment process. And again, to draw on some recent experience, I had a case which resolved in a 2-day detailed assessment. There had been a couple of interlocutory hearings, but the other side's costs, effectively for this claim, were £76,000 for the detailed assessment. That is an eye-watering sum. As I say, it wasn't particularly straightforward, but the cost ought not to have been that high, and ADR would never cost either party anywhere near that. So in my view, ADR can help resolve disputes quicker and cheaper. And I should say that this isn't a plug for my new venture with Guildhall Chambers, Legal Cost Resolutions. It's just my own view that ADR does work. I want to start with, or conclude, before I go on to Q&A, and I do have some questions that have been posed to me beforehand that I will come back to, but I want to close my presentation with a story. It's the story of Miss Madas. Miss Madas was sole director of GSD Law, which was shut down by the SRA, after which it became MHK Limited. Miss Madas presented dishonest claims, which included claiming rates higher than the retainer, breaching the indemnity principle, presenting junior lawyers as senior lawyers, and claiming for work that had simply not been done. Miss Madas admitted presenting a forged CFA and made false allegations against the opposing cost lawyer, which were found to be disgraceful and outrageous. The Solicitors Disciplinary Tribunal found that Miss Madas was guilty of rule breaches, including failure to pay orders made by the legal ombudsman, not producing files when required to do so, and lying to a PI insurer. Miss Madas is not allowed to be a solicitor anymore, so don't be like Miss Madas. Hopefully that's a story that will not resonate with any of you, because I'm sure you would never do any of these things, but just to make it absolutely clear, the indemnity principle is one of the principles that under no circumstances should you breach, and the courts will come down very seriously on any party that does, as will the Solicitors Disciplinary Tribunal. So always make sure when you're presenting cost claims, you are not claiming more than your client is liable to pay, and of course you are claiming the right fee earners and for work that's been done. I don't need to preach to you any further on that, because none of you would ever do that, I know that much. So now is the time for questions and answers. So it's a good time to pop anything into the Q&A box if you have any questions. And as I say, I have had some questions put to me beforehand, particularly in relation to the ADR process. So I'll start by addressing those, if I may. There's 5 questions. The first is, at what point in the process is ADR most appropriate or effective? Well, the answer is it's never too late to consider ADR. But in my view, the sooner you engage with ADR, the better, because quite often it's the costs that have been incurred in the detailed assessment process that will be a barrier to settlement. So the less the parties have already spent, I think the easier it is to resolve the issues. Frankly, by the time you get to the end of the procedural process and you've exchanged points and replies, quite often you'll probably just be better off having the court resolve it than going through ADR. So I think the sooner you engage with ADR, the better. The second question was what sort of timescales to expect? Well, difficult one to answer, is it depends on the issues, but certainly at LCR we have a panel which is likely to expand. So typically we can deal with evaluations or specific determinations within a matter of weeks. However, obviously if we're performing a full quasi-assessment on a multi-million-pound claim, then it could well take a little bit longer. But what I can say with some certainty is that we will be doing things much quicker than the existing regime of going through the courts. The third question is, do I consider ADR to be more attractive for the paying or receiving party? And I think the short answer is both. The intention is that ADR is quicker and cheaper, so everyone should benefit from resolving disputes quicker and by incurring less costs. I mean, the paying party will benefit from potentially paying less in assessment costs, be that their own assessment costs or the receiving party's assessment costs. That's on the assumption the paying party usually has to pay the assessment costs anyway. And of course, the receiving party, reiterating the point that cash is king, benefits from getting their costs paid quicker and incurring less costs themselves. And even if the receiving party is ultimately successful in a detailed assessment, they're not likely to recover every penny of their costs. And I can guarantee you that the party I described earlier that had incurred £76,000 in the cost of the detailed assessment didn't get anywhere near that. So there's always irrecoverable costs. So I think it's beneficial for both parties, but it's only beneficial if the parties are going to engage with the process. As I say, it is pointless to make ADR a box ticking exercise. If you're going to engage with ADR, both parties have to have every intention of wanting to resolve the dispute by using this mechanism. The fourth question, would I expect parties to appoint specialist cost counsel or a consultant to prepare submissions for ADR? Or is the process intended to do away with that requirement? And the second part was, if cost ADR fails, then who picks up the cost of the failed ADR? So I'll deal with this in two parts. The process of ADR, or certainly with LCR, is intended to do away with either party having to incur significant costs. So the contractual arrangement will never prevent the parties from getting their own specialist advice from cost lawyers or cost counsel. Everyone's entitled to do so. But it's designed to be simple. It's designed to declutter and simplify the existing procedure. So where there's an existing procedure of doing bills, points, replies, and then having to advocate at a court hearing, we're trying to give the same level of scrutiny when assessing, but without the same level of costs and delay that you would normally expect. So it's a streamlined, efficient process. So it's not to say you can't appoint people, but you won't necessarily have to. And in terms of the second part of the question, who picks up the cost of the failed ADR? Our personal preference is that each party bears their own costs of ADR and 50% of the mediator's fees, or whoever is dealing with its fees. And the reason for that is that we want both parties to be incentivized to engage in the process properly. If one party is picking up the tab or the costs become costs in the case, then it may well discourage parties from engaging fully with the process. So we say that if both parties are paying an equal sum and having to bear their own costs, then they're far more likely to engage. But of course, ADR is voluntary and it's a contractual process. It's an agreement between you and the other side and you and whoever's dealing with the ADR. So it's all subject to contract. So if the parties want to agree otherwise, if they want to agree that the cost will, if it's unsuccessful, become costs in the case, then so be it. But I think that if you're already having conversations about what happens if the ADR becomes unsuccessful, then I'd question whether everyone's heart is in it. And the final question posed to me was, can costs of failed ADR be recovered in eventual cost proceedings in court? Well, the answer is yes, they can. As I said, my preferred approach is that they're not, and they're dealt with separately because that will focus everyone's minds. But ultimately, ADR is not intended to be a cost building exercise. It's not there just for the point of it. You need to be engaged So the cost can be recoverable if the parties want to agree that, but our advice is that that they shouldn't be, and it should be each party bear their own costs. I'm now going to look at the Q&A and see what questions have been posed here. Bear with me while I just read through these. So one of the questions, again focused on ADR, is cost ADR suitable for disputes over solicitor and client costs? Absolutely. Not just in costs. I think ADR is can be appropriate for any kind of dispute, but solicitor and client disputes, definitely. In solicitor and client disputes, you face issues as to whether the invoices were compliant, whether the client care letter permitted those types of invoices. There's issues about conduct, there's issues as to whether the invoices have given sufficient detail, all sorts of things that an independent pair of eyes can give you a steer on, and I think can help focus minds, particularly if the client's representing themselves and won't necessarily take the solicitor's warnings that perhaps the point they're trying to make is not a particularly good point. I think that's where ADR could be very useful. Bear with me while I read the other questions. There's a question as to if a client instructs solicitors virtually, should a solicitor reduce their hourly rates? Hourly rates historically have been calculated based on cost. So there could be a question in the future with COVID and more people working from home, if cost bases reduce, then perhaps that could lend some weight to the hourly rates reducing. But I think that that's part of a bigger picture when the people reviewing the guideline hourly rates will be looking at overheads and inflation and what is a reasonable markup. And I suspect it may be one factor they take into account, but I don't think at face value, solicitors being virtual or working from home will necessarily have any kind of immediate impact on hourly rates. Bear with me, there is one more question. So there's a question where an order states that the other party has 21 days to file a witness statement as to why they don't want to engage in ADR. Does it mean 21 days from the date that the other party suggests ADR? What if ADR is suggested more than once during the litigation? I have to say it's not a question I've had to answer before, but my gut feeling here is that it should be 21 days from the date that ADR is first proposed. And indeed, in the example I gave earlier, the order for indemnity costs was made from the date that they should have put in their witness statement, and they failed to do so. So in this case, I would say yes, from the date ADR is proposed, you should have 21 days to respond. If ADR is suggested again, then I would suggest one of two things, either saying for the reasons previously given, we don't consider ADR as appropriate and we rely on our previous statement. But if the facts have changed and there are new reasons why you're refusing ADR, then I would suggest putting in a new statement or a new declaration at that time. As I say, the courts are coming down pretty hard on any party that refuses ADR. So the more transparent you can be as to why you're refusing ADR, then I think the more chance you stand of not facing a cost penalty. But I have to say, I struggle to see any reason why, whether it's the underlying litigation or costs, I struggle to see any reason why ADR is inappropriate. And as you'll see from the examples I gave, having a strong defence is not a good reason not to attend ADR, or even winning. In the CBRE case where they won, and they can say, well, you know, we won this, why should we engage in ADR when we've managed to have this claim dismissed? But the point is, ADR is there whether you have a strong case or a weak case. There's effectively no case where ADR is inappropriate in my view. There's always exceptions, so I would always exercise some caution. I was meant to say at the outset that this is being recorded, and I understand that I will be a YouTube star in a couple of days when this gets published to YouTube. Your questions I don't think will be published, but obviously I've read them out and dealt with those, and none of your faces can be seen, so I'm sorry to say that you will not be YouTube stars. I think you will be sent a feedback questionnaire shortly with copies of the slides. There's also, for any of you involved in planning and environmental law, Bristol Law Society are having another webinar next Wednesday, so if anyone wants to register for that, then please do go to the Bristol Law Society website. I will just pause for a few seconds in case there are any of you thinking of posing a question and haven't quite typed it or pressed send yet. There is 10 minutes left of this webinar, so if anyone wants to pose a question, please do so now. Well, there we go. That's my awkward silence then. If anyone does have any questions after the event, then feel free to put them through to the Law Society or to myself. I hope you found this interesting, or I hope you've learned something new, and I hope you're able to use this in your day-to-day practices. So for now, keep well, keep safe, and hope to see you all in the near future. And thanks for listening.